There we go. Okay, so in our last two sessions, we talked about the purchase agreement from the beginning, from page one, all the way down through the financing contingency, through the inspection contingency, through the sellers contributing to buyer's closing costs contingency, and the sale of the buyer's property. So if you missed those, go back and look, and it'll walk through all of those pieces. Our next piece is to talk about the real estate taxes and special assessments part of the purchase agreement. Now, most of this is pretty easy. Let's go backwards for a minute. When you sell a property, property taxes are due for the year for the property, right? And they're usually cut up into two payments, one on April 15th and one on May 15th and one on October 15th, right? And so when you're doing your purchase agreement, you have to determine who's going to pay the taxes from the date of closing, or if the seller's going to pay all of the taxes for the whole year, or if your buyer's going to take it over. This kind of depends on the situation, again, which is why we have wonderful checkboxes here. Okay. The first piece here talks about sellers shall pay on the date of closing all real estate taxes due and payable in all prior years, including all penalties and interest. Okay. Then goes on to ask, buyer shall pay one of these four options, and seller shall pay one of these options. Okay. Usually we're going to prorate. We're going to prorate between both parties, both the buyer and the seller. And what that means is that the seller will pay from January 1st up until the date of closing, let's say June 30th, right? That's your first half taxes. And then the buyer will pay for the rest of the year's taxes. Now, that can be either through an escrow account that they set up with their bank. It can be at closing that they pay for those second half taxes. It depends on the situation. Okay.
One thing I will throw out here for Logan's benefit is
Hmm.
that sometimes your seller won't inform you that they owe for previous years.
Hmm.
So when you get to closing and they have to fork out for the last 2 years previous to this year, that can be a little bit of a shock for them. I had a very close friend do that to me in one of the transactions I did up here in Fargo. So he
Hmm.
owed for 2 years in addition to the year that we were closing.
Hmm.
So you can get a little
Yes.
bit askew if you're doing a net proceeds sheet, and all of
Hmm.
a sudden now they're losing $5,000 because they didn't pay the previous 2 years taxes.
Hmm.
Yeah, which makes sense.
Yeah,
So
you're
that can be
absolutely
the
right.
ordeal.
And so when you're presenting the purchase agreement, because the seller's not required to tell us if they have deferred real estate taxes, right? If we can find
Yeah.
it on the county website, that's great, but they're not required to tell us that, just like they're not required to tell us what their mortgage payoff is.
Right.
Okay.
Right.
So as we do, like Terry said, as we do those estimated proceeds, that's why we call them estimated, because we are not the ones who are doing the search to find all of those things. So if we don't have all the information from the seller, it's going to be wrong. That's just how that works.
And some of these sellers will take offense to the fact that it's not exactly what you put on that net proceed sheet.
Yes.
I had one hold our closing hostage until we renegotiated our commission because he didn't tell us what his payoff was, and it was not the figure that he was envisioning in his mind.
Mhm. And that sometimes happens, which is why you
and
don't.
and it, and it happens. And
Yeah.
sometimes, I mean, we lost a couple $1,000 because it didn't match up on what his net proceeds sheet
Hmm.
said.
Yep. And so that's why you tell them it's estimated, right? You do everything you can to be able to push that. And I say, no, look, it says estimated right on the top. I'm so sorry
And some of
that
them, it
that was
doesn't make any difference.
misconstrued.
Some
And
of them, it doesn't make
sometimes
any
you're right.
difference.
And sometimes it doesn't make sense to be able to continue to argue when what they're asking for is 400 bucks.
Yep.
Okay, right?
Yep.
You
Just
move
give it
on.
away. Yeah.
Yeah.
Yep.
Yeah. So, but hopefully that doesn't happen, but we'll see. But as you are presenting an offer to a seller, You need to point out to them this 214 to 215 because it says right in here that any deferred or not deferred, any taxes that they haven't paid in prior years are their responsibility no matter what. Okay.
Mhm.
Then you decide what happens for the year of closing. And then we get to the wonderful line 220 and 221. So this talks about the difference between part or non-homestead classification. So homes that we sell either have a homestead classification, which means that they get a tax break for being homestead, or they don't. And then they might have, partial or non-homestead classification in the year of closing. Sometimes this matters. Most of the time, the difference between non-homestead and homestead is very small, $100. Most of the time, this doesn't matter. It used to matter, which is why it's still in our purchase agreement, is that the difference in Minnesota in particular between homestead and non-homestead lakeshore taxes was thousands of dollars. Okay. Now that's shrunk significantly. It's a couple $100 at most. However, in line 220 and 221, you do still have to fill it out, even though it says if at the beginning, if the property tax status is part or non-homestead, you still have to fill this out because we don't like blank areas in our purchase agreement if we can help it. Okay. So you then either decide as you're writing this offer on behalf of your buyer, you decide, does the seller pay the difference between homestead and non-homestead, or the seller won't pay the difference between the homestead and non-homestead? And that becomes the buyer's responsibility on the second half of the property taxes. And this
Now,
only counts for the year that the sale is happening. Right? So if the buyer decides that they don't want to put the property in homestead after they buy it, that's not the seller's problem to pay the difference. This is only for the year of closing.
now I have one question that actually relates to buyers that I had in Alexandria and of course in that region, and it has to do with FERPTA.
Ah,
So not sure if they can do the homestead or that classification if they are in legal green card holder but not a
mhm.
resident of the
Citizen.
United States or citizen of the United
Right.
States, because I've had a couple of clients in the Alexandria area that we bought and sold houses, and I'm not sure if we did anything with the homestead classification because they are um, legal citizens of another country.
And so the FERPTA would not come into play because the FERPTA is about taxes on the
Sellers,
sale.
usually, yeah.
Right? Yeah. So it's more about IRS stuff than it is about state taxes on the property. So for this area, it wouldn't come into play because even though they are a foreign body who owns property in the United States, they are still paying real estate taxes on a yearly basis for those taxes. Now, whether they
They
can
also have
homestead
to
or
pay capital gains then when they sell it.
which is where FERPTA comes in. Yeah.
Perfect. Yeah.
That's exactly. And so FERPTA, just so you know, Logan, FERPTA is at the end of the purchase agreement here, and we will talk about it more in depth. But essentially, just a very basic, if a foreign person is selling a home that they own here, we cannot collect, there might be taxes that they owe to the federal government. Okay. Um, the federal government won't be able to track those people. So what they do is they say the buyer, who is a citizen, is required to hold back that money, that taxable money for the seller so that the
Mm.
federal and state government can make sure that their taxes come into play. Now we
Got it.
don't,
So
yeah,
they basically just hand it off and say, okay, then you pay this to the government, right?
right. That's exactly.
Since they can't keep track. Got it.
Yep, because it's a foreign citizen, right? And so most of the time we don't deal with this, but there are some cases that we do. And then we just need to make sure that our buyers are protected. One, if we're on the seller side and we know they're a foreign body, we need to tell them what those requirements are and that they need to go talk to their accountant right away. And then we also need to let the title company know so that they can do their reporting that this is a foreign person, right? Then on the buyer side, we need to let our buyer know, like, listen, this seller is a foreign person. There might be taxes associated with their gain on whatever they're selling. We have to make sure that that tax is paid. Otherwise, by federal law, it becomes the buyer's problem.
Yep.
Okay. So again, it's a conversation with your buyer, conversation with the closing company to make sure money is held after closing until taxes are paid. Okay. Goes on to say kind of what I've already said. Buyers shall pay the real estate taxes due and payable in the year following closing and thereafter. Essentially, Mr. Buyer, you're buying the property. Any taxes from years on are your problem. Okay. It also says that there's no representations made concerning the amount of subsequent real estate taxes. We all know that real estate taxes go up. However, somebody had a lawsuit somewhere down the line that we now have to put in there that say, hey, everybody, just so you know, taxes go up over time. So when you're buying a property, taxes are going to change. Okay. Then we get into deferred taxes and special assessments. Now, special assessments in particular are important when you're selling homes in the city. Not all of us are selling homes in the city. A lot of our homes are country, rural, lakeshore, right? There might not be any assessments whatsoever, but city homes in particular will have assessments depending on what's been done in the area. Assessments are put on the property when some kind of improvement is made by the city. And essentially, the city is giving each of the homeowners a loan for the cost of that improvement, whether it's sidewalk or city water sewer or paving of the road. The city's giving the buyer or the owner a loan at a very small interest rate, and that loan is paid back yearly on their tax statement. Okay, so those are special assessments. What you need to know from a buyer perspective as you're writing a purchase agreement about special assessments is whether or not the taxes are going to throw off the debt to income ratio of your buyer and make them not eligible for the loan, because that will then change how you structure your offer to the seller to make sure that your buyer can buy the property. Okay. So if you talk to your buyer's lender and the lender says, yep, they're good as long as you get these special assessments paid by the seller at closing, then you need to have a conversation with your buyer on how to restructure the offer to make sure that those assessments are paid at closing. Sometimes the seller's already put into their list price that they're going to pay off the assessments at closing. That's already a part of their figures, their estimated net, right? Sometimes it's a negotiating piece, right? Seller's willing to pay some, but not all. Sometimes the buyer's just fine with assuming whatever's left of the special assessments. And so that's what all of this stuff is talking about here.
Now, Logan, when you were doing your training, did they go over abatement?
I'm sorry?
Did they go over abatement for taxes, where they come in at a lower amount to initially sell the property, but let's say after 2 years, like there's a city here in the Fargo-Moorhead area, Horace, where they give you a 2-year tax abatement, and then all of a sudden your taxes jump up to the real amount?
Maybe briefly.
Okay, because that's a big issue here in the Fargo-Moorhead area, because Horace, they do that. They get you in and your taxes are maybe $2,000 a year, and then all of a sudden in 2 years they're $12,000 a year. And a lot of people can't afford that jump in their payment. So you're seeing a lot of, lashing out at these builders for hiding that, because that's what they're doing, is they have a tax abatement where they come in at a lower amount to get you into it. And then once you're into it, then you find out what the real amount is, and it jumps up to that, and you weren't expecting that payment.
Mhm.
And what did you call that? A tax what?
Abatement.
So you'll
I
see
don't think
abate.
Alexandria, you're going to see too much of that, but there are.
I
Yeah,
don't.
I'm sure it's still good to know though.
It is. And abatements, I would agree, Terry. I think a lot of places that we see abatements are in large developments,
Mhm.
where they've come to some agreement with the city. City's like, we need listing inventory, we need homes built. And the builder comes in and says, I'll do it, but I can't cover the cost of all the improvements that need to be made, city water, city sewer, curb and gutter, all of these things. And so let's go ahead and, lower the taxes, and it's almost like a reverse loan, right? Like a loan, you usually pay more interest at the beginning than you do principal, and then it switches at some point. So an abatement is kind of the opposite, right? You pay less taxes, even though you're getting the benefits of the things that they've built, and then you slowly start paying more over time. The thought process being that people make more money over time. So this allows them to get into the home at a better price, right? At a more affordable price. And then as that person's income grows, the taxes will grow with it. But we all are fairly aware that that's usually not how income and costs actually work in the economy, right? So like that's the thought process. And in theory, it's a good thought process. Um, yes. Okay. Okay. There's four options here for taxes: deferred taxes and special assessments. So the first one is asking who should pay any deferred real estate taxes or special assessments, payment of which is required as a result of the closing of the sale. Now, deferred real estate taxes has to do with there are times where a property owner can go to the city or the state or I'm sorry, not the state, the county, and say, I'm having a significant issue, right? Like we've lost, like up in the Iron Range, we've lost a whole bunch of jobs in that area. And so they'll do a deferred real estate tax program where if these people, these homeowners can prove that they've lost a job, that they've gone through a hardship, that they're not able to pay their taxes for a year or two, that the city or the county will defer those taxes until they sell the home. Okay, so that's what deferred real estate taxes talks about. Same thing with special assessments, right? If you can prove that a special assessments that's going through is going to be a incredible hardship on you, some cities and counties will defer any payment for those special assessments until you sell your home or to the new buyer, right? Or they're passing on to the new buyer. And so that's what this piece, line 27 and 28, is talking about, uh, is who should pay those. I would say 99% of the time, the answer is the seller. Sometimes it's not. Sometimes I see buyer on all of these, but 99% of the time it's the seller. Um, because the seller's the one who's deferred it. It's the seller's bill anyway, right? That's the thought process. Then it goes on to say to 229 and 230 are about any installments of special assessments certified for payment within the year of closing. So, like I said, those special assessments are put on your taxes and they're split up per each year of your taxes that you're paying. And so this is talking about just for the special assessments that are supposed to be paid in that year of closing. You have a $20,000 assessment on your home totally, but the payment for this year is only $1,000. And so this question is asking about how are we splitting that $1,000 assessment payment that's due this year? Okay. This one is an up in the air one. Usually the buyer and seller prorate it because they're also thinking about the prorated taxes for the year as well. Usually they prorate it. Sometimes the seller will pay it all, depending on what it is or how much is left. If you're closing at the end of the year, then maybe it makes sense to put the seller pays all of it because you're closing on December 31st. right? That sort of thing. So then we get into special assessments levied here and special assessments pending. Do you guys know or remember the difference between the two?
Between pending and
Yep, between special assessments pending and special assessments levied. No, totally fine. Most people don't. That's okay. Yes. So special assessments levied are ones that are already on the book. The payment is on the books, the work is done, the the assessment is levied against the home. So while 229 to 231 is talking about the special assessment payment for that particular year that you're selling the property, 232 to 234 is talking about the rest of the assessment, right? And so that's what this is. That's what levied is whatever special assessments are on the books right now and that balance. And so you're either going to choose that the buyer will assume the payments for that special assessment or that the seller will pay it off, will pay off that assessment. So in that conversation that I was having at the beginning about special assessments and your buyer's debt to income ratio, making sure their payments match what their monthly payments need to be able to get into the home. This is the area where you would ask the seller to pay for all of the special assessments for the property to make sure that your buyer can afford it. Okay. Then we go into special assessments pending. These are special assessments that either the work hasn't been done yet. They know it's coming, they know a cost, but the work hasn't been done yet, or the work has been done and the assessment isn't on the taxes yet. Okay. They just haven't gone through the whole process yet to get it there, to do the paperwork. So that's what pending is. And when they're pending, because we essentially don't have a bill to pay because the city or the county hasn't gone through their process yet. What we ask the seller to do, if your buyer is asking the seller to provide payment, is they're asking the seller to escrow 2 times the estimated amount to be able to pay that. Now, whatever's not used in that escrow account, once that pending assessment gets paid, once whatever's not used will go back to the seller. Okay. But that's what this is. Most of the time, 232, those levied assessments, and 235, those pending assessments, will just be assumed by the buyer. Okay. You're you're popular today, Terry.
Yeah, I guess. I don't know.
Yes.
Lots of stuff going on. So,
There you are right. Okay. Do we have questions about this piece? Deferred taxes or special assessments?
one of the things I will mention to you, Logan, and this has happened to me in the past, is that let's say you go out and you talk to a seller, and one of the questions that you ask them is, when was the last time you pumped out your septic system? Because you're going to get into that all over the place around that Douglas County area. And they say, well, we've never pumped it. We've owned it for 20 years. We've never pumped it. The first thing in your head better be, well, then you better have $15,000 to $20,000 for a new septic tank, because guess what? Yours is cracked and it's all been leaking out. And so that all needs to be cleaned up, replaced, and it's going to come down to the seller's going to have to pay for it in the long run anyway. So that's a conversation you have with them when you're listing the property, so that when they do get that purchase agreement and the buyer says, well, you're going to have to make this compliant, they already know that it's going to cost them, money.
Yes, always
Yeah,
yeah. Have you dealt with that, Logan, or has Jay talked about that at all yet? About septics and wells? Okay. He will, I'm sure.
Oh, yes.
Mhm. So septics have become we'll talk about this more later too, but septics have become very expensive to put in. when I started 13 years ago, they were anywhere from $5,000 to $8,000, even
Oof.
for a mound system. And now Terry's right. They are now in the $15,000 to $25,000 range just because the
Yeah,
state has changed their requirements for
yeah.
protecting groundwater. That's all it is, right? But part of that change is the tank integrity test, which has to be done for a compliance test. And that tank integrity test, essentially, they have to pump the tank and they look at the inside of the tank and make sure it's not leaking. If, like Terry said, they have not had their tank pumped in 10 to
20
20
years.
years,
Yeah.
then
And you got
most
an issue.
likely there's gonna be something, right? And so having those conversations up front with your sellers, and then also on your buyer side, having that conversation with the buyer on that side, is important. It's definitely a piece. Hmm.
The other thing you also have to consider is the time of year,
Mm,
because if you're closing on it in January, chances are they're not coming out there with the ground thawing equipment and everything to get that septic out and then put the new one in place. It's going to
mm,
be a springtime event. So
right.
just so you know.
Yeah. So in that case, you might have to escrow for those funds from the seller.
Yep.
However, on the other piece of that is that some lenders do not allow an
Like it. No.
escrow to be held.
Yep.
So at that point, you then got to structure the offer a little different, maybe do a buyer move-in agreement or a seller rent back, or which lenders don't always allow, by the way, or extend the closing date and just everybody's on hold until that work can get done.
So it can be set up as like the seller is renting for free from the buyer then until it can be done. Is that what you're saying?
So yeah, so a seller rent back, it's not usually free.
Right.
Sometimes it is, right? So, but the seller rent back is like the opposite of a buyer move-in agreement. So seller rent back is when the buyer says, "Hey, listen, my lender, I know our lender is the one who won't let us close on this until we get this thing done. But we know you need money, Mr. Seller, to be able to go and buy your next home and to move out and do your thing. So." Why don't we go ahead and close on this property? I, as the buyer, will become the owner and I will rent it back to you until a
Until
certain
you
date.
can go. Got
Right.
it.
You have to do a
Yep.
rental agreement in addition to the purchase agreement. So it gets a little more complicated
Yes.
because
Yes,
there's
it
certain
does.
rights that renters have that owners don't.
Right.
And there's certain rights that go the other way too. So
Yes. So there's a lot of hoops. Same thing with the buyer's move-in agreement. Now, I recommend to all of my agents do not go that route if you can help it. Because there's a lot of things that can go wrong. It's usually over a long amount of time. It's not just like a week, it's months. And sometimes the buyer's lender doesn't understand that there's a seller rent back agreement, even though you've asked them specifically, and then it makes the buyer not eligible for the loan. Now they can't buy the property. Like it can cause a lot of problems, but it is available to us for those situations that we need it for. Okay. Okay. Line 239 and 240 talks about buyer. So again, this is very similar to this last line under the taxes piece for the year of closing. Essentially, this is saying the buyer shall pay any unpaid special assessments payable in the year following closing and thereafter, a payment of which is not otherwise here provided. So what's it saying is Mr. Buyer, if we don't cover any special assessments here, just know that you own the property now. So in years coming, they're your problem, not the seller's. Okay. Then it goes on to talk about notices. Notices that the seller receives from any governing authority. This can be the association, this can be the HOA, this can be the city, this can be the county, this can be the state themselves, the DNR, right? Any governing authority. If the seller receives a notice from any of them, they are required to give it to your buyer as soon as possible. Okay. And I always keep as soon as possible in my mind as 24 hours, which is what I used to tell my sellers. As soon as you get that letter and open it, I need a picture, right? We have to provide that information. When you are filling out the property or the purchase agreement for your buyer, unless the listing agent tells you that the seller has received a notice, or unless there's something in the disclosures, your answer is going to be has not. The seller represents that the seller has not received a notice regarding any new improvement project from an assessing authority. Okay. It is on the listing agent and the seller to change that box if that's not true. Does that make sense?
Yeah.
Okay. It then goes on to say what happens when the notice is received and what can happen with the purchase agreement. So I'll just read this to you. It's pretty cut and dry. Any such notice received by the seller after the date of this purchase agreement and before closing shall be provided to the buyer immediately. Now it says immediately, it doesn't give a time frame. I always saw immediately as within 24 hours, right? If such notice is issued after the date of this purchase agreement and on or before the date of closing, then the parties may agree in writing, doesn't say they must, it says they may, on or before the date of closing to pay, provide for payment of, or assume the special assessments. Okay, so essentially what it's saying is that the seller gets a notice that the special assessment is coming before closing. They have to go back to the buyer and it essentially opens up negotiations, not for the whole purchase agreement, but just for this taxes piece.
Yep.
Okay. In the absence of such an agreement, either party may declare this purchase agreement canceled by written notice. Now, it says either party, meaning either your seller or your buyer, if they cannot come to a written agreement for whatever special assessments that they've gotten notice for, that either one can cancel the purchase agreement. This is for two reasons. On the buyer side, they might not be eligible to buy the property anymore because the special assessments have now kicked that monthly payment out of their
Mhm.
available budget. Okay, number one. Number two, well, two, not one, two, the seller might not be able to go do what they intended to do by selling the property, right? By either being able to pay for their next property or pay off their kids' student loans or whatever they wanted to do with that money. That was their only goal for selling this property. And now with these special assessments, if they have to pay all of them or part of them, they can't reach that goal. Then either party can declare this purchase agreement canceled. Okay. Then it goes on to say, if either party declares this purchase agreement canceled, buyer and seller shall immediately sign a cancellation of purchase agreement confirming said cancellation and directing all earnest money paid here to be refunded to the buyer. Essentially, I'm so sorry. We can't work this out. Yeah, you get your earnest money back. We didn't know that this was coming, right? Which makes sense. If your seller wants to fight for the earnest money, they will have to go to court to be able to do that because that's not how this contingency is written. And this is only for this piece, right? Only if a seller receives notice in that time frame. Okay. That's the taxes piece, which I knew was going to be a big one. I think we have 10 minutes, so I'm going to go through the additional provisions piece and then you guys can ask questions real quick. So the additional provisions piece is about previously executed purchase agreements in particular. Okay. There are times where sellers entered into a purchase agreement with another buyer. They're waiting for the cancellation for that buyer because the buyer can't get the loan, didn't like a home inspection, whatever, something happened. And they want to accept this offer, but they have to make it contingent on canceling that first buyer's offer. And this is how we do that. Same thing with a buyer on the other side. Buyer can write an offer, on one property next door that they really wanted was the one that comes up for sale the next day. And so they can submit an offer to that second listing as long as they make it contingent on canceling that first accepted purchase agreement. Now, these have to be accepted purchase agreements, which means all parties have signed and copies have been delivered, right? That's what accepted means. Just because the buyer wrote a purchase agreement on 103 Main Street, right? If the seller didn't accept it and the buyers decide, actually, I want 104 Main Street, they don't have to wait for a cancellation. They don't have to make that second offer contingent on this piece, the previously executed purchase agreement piece. They can, you as the agent on the buyer's behalf, then send a notice, which is usually just an email or a text message or a voicemail. I used to do all three, saying, hey, my buyers are withdrawing their offer. We haven't received anything from you. We're not doing this. We're withdrawing our offer. And then you can go ahead and go to the next listing, right? What this says is this purchase agreement is or is not subject to the cancellation of a previously executed purchase agreement with whatever date that purchase agreement has. And that date is in reference to the date that's on top of each page of the purchase agreement right up here, right? It's not in reference to the final acceptance date. Okay. Most of the time, this answer is not. If you as a listing agent are having your seller accept a backup offer, you have an accepted offer on your listing, your seller wants to accept a second offer to be second in line, this part needs to be filled out. Okay? Because you don't want to make your seller sell the property to two people. You don't want to make your buyer have to buy two properties. That's what this is. If the answer is, and you have a date in here, right? It then goes on to say that the cancellation for this previously executed purchase agreement will be obtained no later than whatever date you need it to be obtained by, right? So if the seller's waiting for that cancellation from the first buyer, put this out a week, right? Depends on the other terms of the offer, on how you're doing it. Maybe your buyer really, really wants this property and the seller's in a fight with the buyer, the first buyer for the earnest money. And they know that they have to go to court and that this is going to take 3 months. Maybe this cancellation is 3 months from now. Depends on the situation. My recommendation is to make this requirement as small as possible for your buyer and for your seller.
You mean as like short, like a time frame?
Yes, that's exactly. Yes. Okay. Then it says if the cancellation is not obtained by this date, that the buyer and seller, that this purchase agreement is canceled. It's just written in there. It's ready to go. Buyer and seller shall immediately sign a cancellation of purchase agreement and directing all earnest money to the buyer. Okay. So you'll notice as we've gone through the purchase agreement that there's different statutory language in here that talks about earnest money. Note to self for you guys, when you are writing a contingency, that is not normal language in a purchase agreement that we already have. You need to be talking about what happens if this contingency is not met, right? What happens to the earnest money? Is this purchase agreement just plain old canceled and everybody will sign a cancellation and move forward? Or is there options for renegotiation when you're writing amendments? And you can pull that language, depending on what your buyer wants to do, you can pull that language directly from inside the purchase agreement because it's already written there. You don't have to think about how to write it. You just have to pull the right one from the purchase agreement, right? Okay, I have about 5 minutes left. What are your questions? Do you have any? Have I given you too much information? That's a possibility.
I don't know. I mean, there's just so much stuff. I mean, it's just kind of slow absorption at this point, trying to map
Mhm.
everything out. I mean, obviously this helps a lot with when I actually get to needing to fill this part out. But I mean, I
Mhm.
have how many other pages to go through too, so
You do. And the listing contract and agency and everything else and finding a lead, there's a lot. Yep. I will tell you, and I tell this to all of our new agents, you will be drinking from a fire hose of the amount of information that you're getting. I don't need you to remember all of it. What I need you to remember is that something was said about this thing that my client is asking. I need to go find out because now it's relevant to me, right? When you're
yep,
building
yep,
your knowledge base, you have to scaffold based on not only your base information, but then experience. And the only way that that scaffolding becomes solid is by experiencing these things. Hmm. So don't be
sense.
afraid to ask.
I'm sure I'll have plenty of questions.
Good. Good. And the answer for a client, clients do not want wrong answers. Clients want good information. And so if you don't know, it's okay to say, I'm not sure on that answer right now. Let me go find out and I'll get back to you. They don't expect you to have all of the answers. What they're paying for you to do is go find the right answer so that they can make good and informed decisions. That's our job.
Mhm.
Hmm. Okay, cool. Well, I think that's all I got for you guys today, unless you guys got any more questions for me. No?
I don't think so.
Okay. Well, thanks so much, guys. We'll do this again next week, 2 o'clock next
Good.
week. And then just FYI, the offices are closed on the 3rd next week. So I'll see you Thursday, and then everybody gets to go party for the 4th of July after that.
Perfect.
All right. We'll see you guys later. Thank
Good
you.
deal. Yep. Nice to see you guys.
You too.